Welcome back. I'm now joined by Keller Kubero with Doling Law. Keller, thank you so much for coming on the show today.
Thanks for having me back.
You're welcome. So I'm excited to learn about what you're going to talk about, which is comparative negligence. What does that mean?
Great question, and hopefully I'll break it down so that at the end of this you'll fully understand it. So comparative negligence is a legal concept, and probably the best way for me to explain it is to maybe just give you an example. So you're on your way back from the pet store. You've just picked up your new friend, Tim the turtle. And you're on the way home and you're involved in an accident, okay? And from your perspective, the other driver who caused the accident ran a red light, and you're dealing with some injuries and damages as a result.
Okay.
One thing that can come up is this concept of comparative fault or comparative negligence. And so let's say that there was a witness that observed the accident and observed that you were reaching over into the back seat at the time of the accident, petting Tim the turtle, and had you not been doing that, you could have avoided the accident, okay? And so basically you're a distracted driver, the other driver has failed to obey a traffic signal, and so he's negligent in that respect. This can be utilized by the insurance company to assert a limitation on your damages. It's basically an affirmative defense. So let's say you filed a lawsuit against this other person. They come in as an affirmative defense and say, okay, yeah, our guy was at fault, but you were also at fault. You were a distracted driver, and that resulted in the accident as well. So what will happen is the trier of fact, which is most often in these situations the jury, they will determine what level of fault could be asserted against you. However, there has to be clear evidence, considerable evidence, to show that you also had some level of fault before the insurance carrier can use this legal theory, this legal concept, okay? To limit your damages. But if they have enough, it goes to the trier of fact. Let's say, hypothetically, your damages in this situation, economic damages, are $100,000. Let's just use that number. If the jury comes back and says you're 30% at fault, the other driver's 70% at fault, they take your level of damages and they reduce it by your percentage of fault.
I see.
So $30,000, 30% would come off the top, and you'd be left with $70,000. If, however, it's determined that your level of fault is equal to or greater than the other driver's level of fault, negligence, you get zero recovery, regardless of what your damages are.
Oh my gosh.
Yeah, zero.
And
so
what
if
about the other driver?
They're not the ones that brought the claim. So it's your claim that you're the plaintiff at that point. So if that happens to where it's 50-50 fault or 51 or higher to you, you get a zero for your damages, and the defendant has defended the claim, and there's no consequence. Why do you care about this? If you get your stuff evaluated early on and we can get out in front of those issues early on, instead of, let's say, waiting until the very end when we just, after the lawsuit's filed, we learn about this witness. Or let's say that we need to have the vehicle tested early on for biomechanical information to learn the mechanics of the accident if there's a question of liability. Those things are so important, and if you are not getting that information to somebody early on to get it evaluated, you're exposing yourself, and that's the point. So it's consistent with this concept of, hey, let's not mess around, let's get these things evaluated, and let's understand the landscape of what we're dealing with so that we can make good decisions as a group. So.
Learn something new every day.
That's right. Well, you should.
Yeah. And now I feel like I'm so prepared for an accident, which is a horrible thing. But thank you for all your knowledge.
Yeah, absolutely. I hope you never have to deal with that situation. But if you do, hopefully you do take something good away from this.
Yeah.
So.
Well, thank you so much, Keller.
Yeah.
And we'll have all that information on our web channel as well, westernslopenow.com.